Welcome to CAEPLA Connections Landowner Talk Radio. I'm Kevin Avram, and with me today, chatting over the kitchen table, as it were, is Keith Wilson, Alberta Policy Chair with CAEPLA, and a lawyer in the Edmonton area. Keith, if I'm not mistaken, I think you also worked at one time in the office of the Farmers Advocate in Alberta.
That's right. Good morning, Kevin, and I worked for the Farmers Advocate office for 8.5 years dealing with landowner issues throughout the province.
Jim Ness is joining us from the east central part of the province. Jim is a cattle rancher, farmer, and licensed land agent.
Good to be here.
Dave Core. Dave is the chairman of CAEPLA. Incidentally, CAEPLA is an acronym that stands for the Canadian Association of Energy and Pipeline Landowner Associations, and CAEPLA is the sponsor of this program. Welcome, Dave.
Good to be here, Kevin.
Keith, Dave, Keith, the two of you met with Minister Mel Knight earlier this week to discuss the government's proposed amendments to Bill 36, and I'm sure our listeners want to hear about that meeting and the observations that you would make. But before we go there, Dave, I'm wondering if you could briefly comment on the previous relationship between landowner organizations and Minister Mel Knight.
In 2008, Nova Gas Transmission Limited, owned by TransCanada Pipelines, applied to transfer 25,000 kilometers of their pipeline system from provincial Alberta jurisdiction to federal jurisdiction. And it was November of that year that the Alberta landowners attended a hearing at great cost to try and protect their long-standing rights. And it was under Mel Knight's watch that this happened. Before the hearing, the landowners approached the minister's office and asked him to consider the best interests of landowners. The issues that the rights that landowners lost were the fact that they lost the right to annual payments. Crossing restrictions were put on them.
Let me stop you there. Just what do you mean landowners lost the right to annual payments? Do you mean annual payments on pipelines on their property?
Yes, that's right. Under provincial regulations, landowners had right to annual payments on their pipelines. Under federal regulations, there's no way for landowners to receive annual payments on future pipelines in those corridors. They also lost certain crossing rights under Alberta law. Landowners have the right to cross with vehicles and farm machinery. Under federal law, you have to have permission to cross the pipe. They also lost the right to cost recovery and taking part in hearings under federal law, and under abandonment law in Alberta. The regulator has a remedy for liability and costs, and the company is always held liable. Under federal law, the National Energy Board can approve abandonment in place, and the pipeline becomes the landowners.
I guess the point that we're making for landowners here is that there is a history here where the interests of landowners have either been somewhat ignored or not really held in high regard on key issues by the provincial government, and specifically by the minister that's now looking at Bill 36. Keith, if I could, you and Dave met with the minister earlier this week, and you met with the press after that. First of all, why was the meeting called?
Well, it was never really made clear. The minister had contacted me and asked us to come and meet with him and at the legislature, and Dave and I went in there and introduced ourselves as being with CAEPLA, and he wanted to talk about the concerns that have been circulating throughout Alberta on what we refer to as Bill 36, the Alberta Land Stewardship Act.
Just to give our listeners some background, Keith, would you give us a quick synopsis on what is Bill 36, the original version of the bill prior to the proposed amendment?
Certainly, and I can do that by telling you a little bit about what happened and telling the listeners what happened in the meeting. You know, the minister started by describing the goals of the legislation. For example, he said, you know, everybody he's met in Alberta tells them that they want the government to plan better and deal with better with issues of water allocation and cumulative effects management and conservation decisions. And so those are the goals of the legislation. And I indicated to the minister that I'm one of those Albertans that agrees those are good goals, explained to him that the problem And the reason for concern is not related to the goals of the legislation. Importantly, it's the tools that the government has given itself. In particular, the cabinet now has unrestricted power to arbitrarily rescind. They used use the word extinguish. They've changed it to rescind. It means the same thing. It's just a softer word. But under this legislation, the cabinet can rescind a water license. They can rescind development rights. They can rescind a crown grazing lease, an oil and gas mineral lease, timber harvest agreements, oil sands leases, all these sorts of things. The building blocks of the economy. And this is unprecedented for a government to move that much power into the cabinet room. I explained to the minister, and I explained to your listeners now, that in addition, what the concern is the way they've either reduced or eliminated entitlements to compensation. And thirdly, they've removed from citizens the traditional remedies of the courts. In other words, if you feel that the government hasn't followed the rules, if you feel that the government's treated you arbitrarily or capriciously, traditionally the hallmark characteristic of a rule of law democracy is that you can take that before a court, before a judge, and the government's not above the law. This law has been deliberately written so that the government is above the law, the government is the law, and no one can take them to court. The original version, it outright said you're not entitled to compensation. The amendments that they've put in the legislation say you might be entitled to compensation, and that's hardly reassuring. The ministers stated publicly, and the premiers stated publicly, that one of the goals of the amendments was to make this legislation absolutely clear. So there was no room for doubt or uncertainty, and everybody would know what it means. I myself, as a lawyer who specializes in a number of these areas, I had to read some of these amendments several times to decipher them. So I don't think they've achieved that goal of understanding at a minimum. It's my view that they've made the issue of compensation more confusing and less clear. When you take a look at what the government's goals are, and you look at the tools and the powers that they've given to themselves, that the legislation needs to be repealed. And I explained this to the minister, that you can achieve the goals of the legislation without giving the cabinet unprecedented powers, without taking away the rights of Albertans, without creating economic uncertainty about the building blocks of our economy. Because remember, what's the economy of southern Alberta without water rights and grazing rights, and what's the economy of the province without, even for the oil and gas industry, to have certainty with respect to their leases and forestry and so on. We're a resource-heavy province, and this legislation creates significant uncertainty around those resource rights. So, one of the things I tried to do in the meeting was walk the minister through very specific provisions of the legislation and help him understand that these concerns are real. And I should add that, and as many of your listeners will be aware, Kevin, that the concern is not restricted to just this piece of legislation, and I was at pains to explain that to the minister. What Albertans see is a trend. When you look at Bill 19, which is the Land Area Assembly Act, and how it removes the normal entitlements of the Expropriation Act, how that piece of legislation allows the cabinet, gives the power to the cabinet to freeze your land for extended periods of time, I'm talking 20, 30 years, without the right to compensation, is a workaround from the Expropriation Act. And then you look at Bill 36, the Land Stewardship Act, concentrates all these powers in cabinet. Then you look at Bill 50, the Electric Statutes Amendment Act, which took the public needs assessment and moved it, the question of whether or not a power line is truly needed, the one that would be forced upon your property and the one you'll be forced to pay for. It took that question of whether that power line, that transmission line, is needed from the independent public hearing room of the Utilities Commission and moved it into the back room of Cabinet. You see this trend of concentrating decision-making and powers in the Cabinet and taking away the processes that Albertans and citizens of other provinces have had, throughout the history of this country, and removing those traditional rights.
It strikes me that if you look at the package of provincial bills that you just mentioned and view that in the context of the situation that Dave Core just described a minute ago, the provincial government's position and disposition on the jurisdictional transfer of the Nova Gas pipeline system, it would appear that there seems to be evidence that that the provincial government's regard for property rights is not quite on the radar screen on a number of issues. I'm not sure. Would you? I think that's a fair statement. Jim, would you care to comment on that? Do you think that's a fair assessment?
The landowners that I talk to every week are pretty disturbed. First of all, some of the bills, like Bill 19, Bill 24, and Bill 50, there was no public forums to determine what the public thought. There was a small process of public forums regarding Bill 36, but of course the public was never ever faced with the punitive portion of Bill 36 that it is so intrusive. But the MLA that tabled Bill 19 and Bill 50 in the legislature did at no time bring it up in front of his constituents or have any public forums.
Well, you're raising a good point, Jim. I think the problem that you often run into in public policy is that if governments make decisions in a back room without involving the public, then there's always questions to ask as to why and why stakeholders were not permitted to inquire or to state their case as effectively and as persuasively as they could. Keith, you held a number of meetings throughout the province, and if I recall correctly, there are a number of individuals, including members of the provincial government, that originally indicated that your statements about their land bills, or specifically Bill 36 we're talking about now, but that you were exaggerating, or I think the word misleading was used. If I read a report where one of the ministers referred to, or ex-ministers, I guess, referred to you as a Picasso, which I'm not quite sure what that means, but in light of the fact that you were accused of misleading individuals, and then the government on the heels of those accusations against you went back into the legislature and essentially attempted to clarify or redesign. I don't know, would you use the word redesign or clarify, or would you call it Bill 36 light, or how would you refer to the new bill?
Well, I think, clearly a number of the amendments they made confirmed that what I described to be the features of the legislation were accurate. Otherwise, the amendments serve no purpose. But, what's troubling for me is that a number of the other amendments that they've made, they've purported, or they're holding out to Albertans that we fixed it. And I wish that were true, but it's not true, and it's not accurate legally. And what I see in a number of the provisions is what I'd call creative drafting or sleight of hand. There's words that will cause many people to read and think, oh, it looks like there's something there. But when I read them with my legally trained eye, I go, that doesn't create any rights at all. There's one section they've added that says nothing in this legislation takes away or limits or reduces people's rights to compensation under other pieces of legislation. Well, the concern is not about the powers under other legislation. The concern is about the Cabinet's power to rescind, with no need to justify, people's existing rights, water rights, development rights, resource extraction rights. That's the concern. So whether or not some other legislation has a process is irrelevant. The question is, does this legislation create a clear entitlement to compensation?